Under Section 84, presumption as to collections of law and reports of decision. This section should be read along with Section 38, which make the relevant statement as to any law and rulings contained in official printed books of any country. It dispenses with the proof of the genuineness of authorized books of any country containing the law and reports of the decision of the courts. Section 57 authorizes the courts to take a judicial notice of existence of all laws and statutes in India and in UK. Section 74 recognizes statutory records to be public record. Section 78 lays down the method of proving the statute passed by the legislature. Under Section 85, presumption as to powers of attorney. The court shall presume the due execution and authentication of a power of attorney when executed before and authenticated by a notary public or court or judge, a magistrate, Indian consul or vice consul. The section does not exclude other legal mode of proving the execution of a power of attorney. The court can presume the notary public must have satisfied himself about the competence of the executant. The presumption applies not merely to local notaries but also those functioning abroad. A power of attorney in favor of a company's permanent delegate in Delhi, authenticated by a judge of a foreign country, due execution and authentication was presumed. Power of attorney includes any instrument not chargeable with a fee under the law relating to the court fees for the time being in force, empowering a specified person to act for in the name of the person executing it. Notary public is an officer who takes note of anything which may concern the public. He attests the deeds or writings to make them authenticate in another country, but principally employed in mercantile affairs to make protest of the bill of exchange. Under Section 138 of the Negotiable Instrument Act, the central government is authorized to appoint notaries public within any local area. There can be no presumption without compliance of the formalities. The mere fact that the documents had not been drafted or typed out by the executant before the notary public, and the fact that the typed matter duly signed by the executant was presented before the notary public did not in any way make the execution and authentication doubtful. An application for regularization of a building plan was filed through a power of attorney which did not convey or confer any title or interest, whether vested or contingent. The court said that the application was not liable to be rejected because of the fact that the power of attorney was not registered. The power of attorney was duly notarized and therefore carried the presumption of validity under Section 85. The officer order insisting upon registered power of attorney had no legal sanctity. The presumption as to due execution and authentication is available in favor of the original power of attorney holder, provided the mandate of a section is duly followed. For creating the presumption about a foreign power of attorney, the document has to be authenticated by the Indian consul or the relevant Indian authority. That was not done, nor was the relevant law in the United States about the power of notary public cited. The presumption under the section was not attracted. Section 86, presumption as to certified copies of foreign judicial records. If a copy of foreign judicial record purports to be certified in given way, the court may presume it to be genuine and accurate. It, however, does not exclude other proof. For under section 65 and 66, secondary evidence may be given of a public document without notice to the adverse party when the person in possession of a document is out of reach or not subject to the process of the court. A photostat copy of a decree of a foreign court was held to be admissible and also capable of being acted upon by the court, provided only that it was certified as required by the section. This section contains an instance of a document which section 65 clause F seems to refer to. The provisions of this section are imperative and must be complied with. Under section 87, presumption as to books, maps and charts. The court may presume that any book to which it may refer for information on matters of public or a general interest, or any public's chart or map was written and published by the person and at the time and place by whom or at which it is purported to have been written or published. See section 36 and 83. A map is nothing but a statement of the market thereof regarding the state of configuration of a particular site and object standing thereon by lines and pictorial representation instead of by words of mouth, and admitting such a map in evidence without calling the maker thereof is admitting statement by a third party who is not called as a witness and amounts to admitting hearsay evidence. So, mere proof of map by itself is only proof of fact of the preparation of the map, and apart from independent proof about the correctness of the content, it cannot be said to have any bearing on the matters in issue and cannot be admitted into evidence unless shown to be admissible under any section of this Act. Under section 88, presumption as to telegraphic messages. The court may treat telegraphic messages received as if they were the originally sent, with the exception that a presumption is not to be made as to the person by whom they were delivered for transmission, and unless the non-production of the originals is accounted for, secondary evidence of their content is inadmissible. It must be proved that the message purports to have been addressed. In the absence of such evidence, the telegram cannot be held to have been proved. A telegram is a primary evidence of the fact that the same was delivered to the addressee on the date indicated therein. The court is forbidden to make any presumption as to the person by whom the telegram was sent. When the detainee sent a telegram conveying that they were illegally detained, but the same was not taken into consideration, it was held that telegram is not an authenticate document. It is like an unsigned anonymous communication. Unless telegram is confirmed by subsequent signed application, a representation or an affidavit, the content of a telegram have no authenticity at all, and the same cannot be taken into consideration. The section enables the court to accept the hearsay statement as evidence of the identity of the message delivered with that handed in. Under section 88A, presumption as to electronic messages. This section provides that the court may presume that an electronic message forwarded by the originator through an electronic mail server to the addressee correspond with the message as fed into his computer for transmission. The court is not authorized to make any presumption as to the person by whom such matter was sent. The explanation to the section explains the meaning of the term addressee and originator. It says that these terms will have the same meaning as is assigned to them in a clause B and ZA of section 2 subsection 1 of the Information Technology Act. Section 2(1)(b) says that addressee means a person who is intended by the originator to receive the electronic record but does not include any intermediary. Section 2(1)(ZA) says that an originator means a person who sends or generates or stores or transmits any electronic message or cause or any electronic message to be sent, generated, stored or transmitted to any other person but does not include any intermediary. Under section 89, presumption as to due execution of a document not produced. When document is called for and not produced after the proper notice so to do, the court shall presume that it was duly attested, stamped and executed in the manner prescribed by law. The sections refers only to stamp, execution and attestation of a document. It restricts to cases where notice to produce a document is given to a party. Where document is shown to have remained in unstamped for some time and after its execution, the party who relied on it must prove that it was duly stamped. Where the defendant failed to produce mortgage deed despite notice, presumption that the mortgage deed was duly attested could be drawn. Under section 90, presumption as to document 30 years old. The object of this section is not to make it too difficult for a person relying upon ancient document to utilize those documents is proving their case. Intended to do away with the insuperable difficulty of proving the handwriting, execution and attestation of a document in ordinary way after the lapse of many years. It does away with the strict rule of proof of the private documents. When document or is purports to be more than 30 years old, if it is to be produced from what the courts considered to be proper custody, it may be presumed that the signature in every part of such document which purports to be in handwriting of any particular person is in that person's handwriting, and that is was duly executed and attested by the person by whom it purports to be executed and attested. 30 years old document produced from a proper custody, not looking ex facie suspicious, presumption could be drawn in favor of the document. Where the document relied on was not more than 30 years old, finding of the court based on no evidence could be interfered with. It is not necessary that the signature of the attesting witnesses or of the scribe to be proved, for if everything was proved, there would be no need to presume anything. There can, however, be no presumption as to who the person who executed the document was and what authority he had to execute a document, and whether he had the requisite authority, or whether the content of the documents are true, or the document has the legal effect it is purports to have. Presumption under section 90 in respect of 30 years old document coming from a proper custody relates to signature, execution, attestation of a document, that is to its genuineness, but it does not give rise to presumption of a correctness of every statement contained in it. That the content of the document are true or it had been acted upon have to be proved like any other fact. State of Bihar versus Radhakrishna Singh. The Supreme Court said that the court relying on the genealogy of a family must be guard itself against falling into the trap laid down by a series of documents or labyrinth of seemingly old genealogies while deciding rival claims. The presumption allowed by this section is not presumption which the court is bound to make, and the court may require the document to be proved in the ordinary manner. Before the court is justified in making a presumption in favor of genuineness of the ancient document, it should be satisfied anew that there is a good ground for accepting it as a true. If there are circumstances in the case which throw great doubt on the genuineness of the document more than 30 years old, even if it is produced from proper custody, the court may exercise its discretion by not admitting the document in evidence without formal proof and rejecting it when no such proof is given. The presumption permitted by this section in the case of a document purporting to be 30 years old, that it was duly executed by the party by whom it is purported to be executed, includes the presumption that when the signature of the executant purports to have been made by the pen of the scribe, the letter was duly authorized to sign for him. Under this section, this presumption does not apply to a seal, and hence no such presumption can be drawn in favor of a document which bears only seal, but neither any signature nor purports to be in handwriting of a particular person. There was a dispute about the caste of an election candidate. His father's application for admission in a school was produced. It showed the caste. It carried the father's thumb impression. Document was more than 30 years old. It attracted the application of a section 90. The mere fact that there was difficulty in reading one figure in the date was not considered by the court as a ground for rejecting the document. Entries in the revenue record made more than 3 decades before were presumed to be authenticate. Presumption under this section extend to testamentary document. A will purporting to be 30 years old and produced from a proper custody may be presumed to have been duly attested and duly executed. The court must, however, act with extreme caution and utmost circumstances. The period of 30 years will run from the date of the will and not from the date of the testator. A. Presumption as to electronic record 5 years old. Where the electronic record purports to be or proved to be 5 years old and is produced from any custody considered proper in a particular case, the court may presume that the digital signature which purports to be digital signature of any person was so affixed by him or by any person authorized by him in the behalf. Defining the expression proper custody, the explanation to the section says that electronic records are said to be in a proper custody if they are in the place in which and under the care of the person with whom they would naturally be, but that no custody is improper if it is proved to have been had a legitimate origin or the circumstances of the particular case are such as to render such an original probable. This explanation also applies to presumption under section 81A to the Gazette in electronic form.